Welcome to the Joint Base Charleston Legal Office Family Law Presentation on Divorce. This presentation contains material that will prepare you for your initial telephone consultation with one of our attorneys. This presentation is meant to provide a general overview of the divorce process in South Carolina for military members, including the Coast Guard, as well as answer some of the most frequently asked questions and links to helpful resources. Before consulting with a staff attorney, you must watch an informational slideshow on your subject in its entirety. As you watch, remember that this should not be considered legal advice. Military legal assistance attorneys cannot represent you in court. They can only answer questions and provide general legal advice. The divorce process can be complicated and time-consuming. Even after speaking with our staff, many members should consider consulting with and possibly hiring a private attorney. Our office does not provide attorney referrals. Finally, this presentation will only cover family law matters under South Carolina law. If you or your spouse will be moving to another state as part of the separation process, you should consider consulting an attorney from that state. Each state has unique and varied divorce laws. Additional informational presentations on child custody, paternity, and financial support for family members can be found on our YouTube channel at Charleston Base Legal Office. South Carolina Divorce, the fundamentals. For this presentation, think of your divorce as a contract where you and your spouse lay out the ground rules for moving forward in your separate lives. This includes how you will split up property, handle money matters, take care of the children, and more. You must recognize that negotiation is key. Just as in purchasing a car or home, it's crucial to negotiate favorable terms, such as seeking lower costs or better rates. The party on the other end is doing the same. Recognize that compromise is necessary, as both parties are striving for the best outcomes. There will also be unique emotional dynamics during the divorce process. Emotional challenges, such as significant life-altering emotions that make it hard to detach feelings from the proceedings. You may have been wronged by your partner, which makes negotiation more frustrating or difficult. Understand there are benefits of emotional detachment. By setting emotions aside, you are better equipped to reach a consensus that not only benefits you and your spouse, but also your family. Despite its challenges, this approach can also reduce costs significantly. Remember that divorce is a state proceeding. Like other contracts, divorce is governed by the laws of the state you are in. The fact that you or your spouse is in the military won't significantly impact your divorce unless you are deployed or someone plans to move to another state. It doesn't matter where you were married, only where you live when you file. Your home of record might allow you to get divorced in that state without being physically present there. There are two basic types of divorces in South Carolina: contested and uncontested. A divorce is contested when the spouses do not agree on some or all aspects of the divorce. In that case, the parties will go to mediation, and if that fails, to court, where a judge will examine evidence and call witnesses. The contested divorce process takes longer and often means one or both parties must hire a private attorney, which can be expensive. By contrast, in an uncontested divorce, also called a simple divorce in South Carolina, the spouses agree on all of the issues, so there's no need for the judge to hold an evidentiary trial. An uncontested divorce is faster and much cheaper than a contested divorce. Most couples can use state-approved self-help forms in an uncontested divorce, which typically negates the need to hire an attorney. The uncontested route is almost always the best option for couples with no children. South Carolina divorce, the complexities. In addition to contested and uncontested divorces, South Carolina categorizes divorces as either fault or no fault and simple. A fault-based divorce is the dissolution of a marriage in which one spouse must prove that the other has violated the terms of the marriage, cast blame, and provide evidence to support their claims. Most at-fault divorces are contested. While technically possible to have an at-fault uncontested divorce, it is rare because of the potential UCMJ implications. You must hire an attorney to help you prove the at-fault basis for a divorce. Grounds for a fault-based divorce in South Carolina are adultery, habitual drunkenness or narcotics abuse, physical cruelty, desertion for 1 year. Usually, the fault basis in a military divorce is adultery. To establish adultery, you don't need to prove it actually happened. Instead, you can prove adultery by showing inclination and opportunity. Judges in South Carolina will likely require substantial proof, including text messages, pictures, videos, etc. Hiring a private detective is common. If you file using an at-fault basis, there are advantages and disadvantages. The advantages of proving an at-fault ground are: you can typically get a divorce much faster. If the other party contests the fault ground, it will take longer, but if you prove fault, you do not have to wait for a year. If proven, the non-adulterer can receive significant financial benefits in an at-fault divorce. These include alimony, a more favorable distribution of marital assets, custody advantages, and possibly attorney fees. However, it's important to note that these benefits are not guaranteed and depend on the specific facts of your case. The party found guilty of adultery cannot typically seek alimony against you. The disadvantages are: you will need to hire an attorney. Attorneys are expensive, and most require an upfront payment, called a retainer, of anywhere from $5,000 to $10,000. Litigated divorces can cost anywhere from $15,000 to $30,000 or more, depending on the facts of your case. We have heard of divorces costing military members over $150,000 in extreme cases. If you want to pursue a fault-based divorce, you should be prepared to spend money up front. Even if you are ultimately awarded attorney fees, your spouse usually won't be required to pay them until the end of the process. Choosing an at-fault divorce route almost always leads to a more stressful and acrimonious process for all parties involved. This heightened emotional strain is important to consider when deciding on the grounds for divorce. By contrast, a no-fault divorce is what it sounds like. Simply, the parties no longer wish to be married but are not alleging one of the fault grounds covered previously. Important point: even if you believe your partner did various things to cause the marriage to end, aka you think the divorce is their fault, you still have to allege one of the grounds covered on the previous page for the fault to be legally recognized. The primary requirement that must be met to file a no-fault divorce is that you must have lived separate and apart from your spouse for 1 year before filing. South Carolina is very strict on the 1-year requirement. You cannot spend so much as one night with your spouse under the same roof as a married couple, or the countdown starts over. You will have to prove that you have lived separate and apart from your spouse. Most often, proof requires testimony by the spouse asking for the divorce and an independent witness who testifies to the same thing. There are no exceptions to this rule. It is possible to file a no-fault divorce without hiring an attorney if the parties agree on all matters, called a simple divorce. South Carolina has provided all necessary forms and instructions here, or you can search the web using the South Carolina Self-Help Divorce Packet. It is advisable to file a simple divorce, uncontested, no fault, where possible. You can typically do this without the need to hire an attorney. To be eligible to file a simple divorce, you must meet the following requirements. 1. You are filing for a no-fault divorce using the grounds that you and your spouse separated for at least 1 year and haven't lived together at any point during that year. 2. You have no marital property or marital debt, or you have reached an agreement on how to divide the marital property and debt. And 3. You have no children with your spouse, and neither spouse is pregnant. Or 4. You have minor children together and agree on the terms of child custody, visitation, and child support, and the child support agreement meets the minimum requirements set by South Carolina's child support guidelines, which can be found online. 5. You or your spouse has lived in South Carolina for at least 1 year before filing for your divorce. Or you and your spouse both live in South Carolina and have lived there for at least 3 months before filing for divorce. Remember, Do a web search for the South Carolina Self-Help Divorce Packet. You will be presented with forms, instructions, and other resources to file the divorce yourself. Our office can help you by answering questions. South Carolina Divorce. The next steps. If you are ready and meet all the requirements to file a divorce, you will go to the county's family court where you live. You will need, at minimum, the following forms: family court cover sheet, certificate of exemption, summons for divorce, complaint for divorce, financial declaration form, acceptance of service, request for hearing, and final order of divorce. These forms, along with others that you might need, and additional instructions on the divorce process, as well as the paperwork requirements, can be found here and at the links listed at the end of this presentation. Also note that the base office does provide notary services. In South Carolina, property division during a divorce is governed by the principle of equitable distribution. This means that the court divides marital property fairly, though not necessarily equally, based on various factors. Here's an outline of how property division generally works in South Carolina. The first step is distinguishing between marital and non-marital property. Marital property includes most assets and debts a couple acquires during marriage, regardless of whose name is on the title. Non-marital property includes assets and debts owned by either spouse before the marriage, inheritances received individually during the marriage, and gifts received by one spouse from third parties. A military retirement is considered military property. In regards to marital property, the court will divide the marital property based on several factors, aiming for a fair distribution. These factors include the duration of the marriage, the spouse's ages at the time of the marriage and at the time of the divorce, the marital and non-marital properties of each spouse, the current and potential earning capacity of each spouse, the contribution of each spouse to the acquisition, preservation, depreciation, or appreciation in value of the marital property, including the contribution of a spouse as a homemaker, the physical and emotional health of each spouse, the need for additional training or education to achieve a spouse's income potential, the non-marital and marital liabilities and needs of each spouse, custodial provisions for any children, the existence or absence of marital misconduct or fault, tax consequences of the property division. South Carolina divorce, final thoughts. It is time to ask the tough questions. Is divorce right for you? Even if your divorce is classified as simple, it is still a lengthy process. South Carolina favors reconciliation, especially where children are involved. Give yourself some time to see if you can work out your differences. What are my rights? This is probably the most common question clients call in with. Many clients believe their status as military members or spouses confers unique benefits. This is generally not the case. Like anyone, you have the right to get a divorce, to have a court fairly split your property, and to have your children provided for. Alimony for you, while possible, is rarely granted long-term. The military, via DFAS, does provide certain benefits if you are married to the member for at least 10 years that overlap with the member's service. How long will you be in South Carolina? If you are PCSing soon and your spouse is planning to move to another state, it probably doesn't make sense to file for divorce in South Carolina, given the lengthy wait time. Most other states have significantly shorter wait times. Leaving the marital home to another state? Unless you or your children are in physical danger, you should not take children across state lines to keep them away from the other parent. A state court judge will not look kindly on such actions. Always attempt to communicate with your spouse. Pro bono legal assistance? In rare cases, you might be eligible for free legal services from the American Bar Association's ABA Military Project. The ABA typically grants our office 1 or 2 such cases a year. Hiring an attorney? Often hiring an attorney is the best option. While our office cannot recommend a specific attorney, we suggest you ask any attorney you're considering hiring about their knowledge of the military. This shouldn't be your sole factor in hiring them, but knowledge and familiarity with the unique issues that can present in the military context is always a bonus. Remember, unless you and your partner agree on everything, you will likely need to hire an attorney, especially where children are involved. The UCMJ and adultery? If the military member has committed adultery, spouses are often angry. Many want to get the member in trouble for their actions. Adultery alone is rarely prosecuted by the military. helpful links. These links will provide further information and access to checklists, forms, frequently asked questions, and much more about the divorce process. Now you're prepared to consult with our attorneys. We trust this presentation has offered valuable insights into the divorce process and addressed some common questions. While the information shared here is not an exhaustive guide to every aspect of divorce, it aims to lay a solid foundation for your understanding, empowering you to engage more effectively with our attorneys. As you prepare to meet with one of our attorneys, you'll be equipped to ask informed, tailored questions that reflect your unique situation. Should you have additional questions not covered here, we invite you to explore our other presentations on family law topics, such as separation agreements, child custody, and paternity, for further guidance and support.